arising dispute meet this requirement, then it falls under the scope of the compulsory jurisdiction of the dispute settlement mechanism of the WTO. And here, when you read through the text, you also realize that all the procedures and deadlines have been provided in detail, and all the players need to follow strictly follow the schedule. And you also have the very basic idea about this mechanism as a kind of complaint-driven mechanism. What does it mean by complaint-driven mechanism? Student, do you have any idea about this characteristic? Complaint-driven. Any answer? Well, why people usually used to think about the dispute settlement mechanism under the WTO system is a kind of complaint-driven because, and mostly stick with the rules of decision making by negative consensus, which I think and I believe I may mention to you last week. Well, when we talk about negative consensus, it's mean that, and we may jump into this issue by the next slide. But here we may have the very basic idea that in the last in the previous of GATT, well, normally a lot of decisions relating to the dispute settlement activities has been veto, or the respondent used to use, or they gonna likely to use the right of veto. And so when they try to establish a panel, this decision can be locked by the decision making of consensus. And so the respondent can just say no, and so the panel can never be established, and so the dispute settlement procedure are facing, or it's facing with the risk of being locked by the respondent. And so now when they move to the control of the WTO, now they think about how to fix these issues, and so they choose and they replace consensus by negative consensus. And by using negative consensus, any request given by the complainant has normally will be supported. And so you may have a better idea by the next slide. But here, this is the thing you should keep in mind when we continue talking about the negative consensus rules. And it is also a very a special point when you mentioned or when we talk about dispute settlement system of the WTO. And also about quasi-judicials, that mean as I have mentioned earlier. Now, normally at international level or international court, they have only they provide only one chance for a case to be examined. But here under the system of the WTO, they have suggested one more chance for a case to be re-examined, to be reviewed, and so it helped to make sure that the judgment has been published with a very sufficient result, and focusing on the law and sticking with the law, fixing any arising error, if there is, that on the things, on the error that's happened at the previous stage. That means at the panel reviews. And the last characteristic, automaticity. Well, what does it mean by automaticity? That means, well, this characteristic also stick with the complainant support, and it's also stick with negative consensus, because the thing gonna be processed automatically. By applying these negative consensus rules, the procedure is going to be, it's going to keep going, and without any locking from the respondent. Now we will talk about it right now, right away. Now, before jumping into negative consensus, I need to introduce to you some main characters, main players who are gonna join into these procedures, and so that you're gonna have a very basic idea about the system. Now, the first one is the dispute settlement body. Dispute settlement body. Well, if you read through the text, then you may have the idea that the WTO dispute settlement arrangements are placed under the supervision of a single dispute settlement body. And as we have introduced last time, that the DSB is in fact the WTO General Councils, and they sit for this purpose under a different names, and normally but not necessarily with a different chairman. Okay, and the dispute settlement body has the authority to do what? They play a very important role in the system, as they have the right to establish panels, they have the right to adopt panels and AB reports. What else? They have the right to maintain surveillance on implementations of rulings and recommendations. And they also have the right to authorize suspension of concession and obligations. I hope you have very basic idea with these terms, because you might heard about it for the first time. Now, I may have provide a little explanation in Vietnamese by the end of today's sessions, but you need to follow me very strictly. So here, for the very first idea, the DSB have the right to give the decision in specific issues strictly relating to the dispute settlement mechanism and the dispute settlement procedures. Okay, but you all know that the dispute settlement body have the representative of all WTO members, and so normally they have they have not much idea, they have not learned much about the WTO law and the WTO agreement system, and so they may not have sufficient knowledge to handle a case, and so that is the reason why they need the support from the panel and the appellate body. So we have here the panel and the appellate body as a kind of sub-body under the system. Okay, and also here we also as you have noticed on the slide that we may see the parties, that means the disputing parties, including the complainant and respondent in the case. We also have third parties who may have their right in connections in relating to the disputing issues. And here you need to notice that the party and third parties in the system who may join into the dispute settlement procedures need to be the WTO member. So other organizations other kinds of entities don't have the ability to attend into this kind of mechanism. That's the things you need to keep in mind. And you may see experts in NGOs. Well, sometimes, if necessary, the dispute settlement body, in specifically the panel and the appellate body, may ask for the support from experts if they think that their explanation may support to the rulings. And about the NGO, they may provide evidence or documents to support one party in a dispute, and the AB or the panel have the right to decide to use those kinds of documents or not. But yeah, sometimes they have the chance to join into the system. So about the secretariat and general director, the general director can nominate the panel members pursuant to the dispute settlement understanding upon recommendation by the secretariat. And so in this case, then they may join into the system. All right, now we are going to spend a little time to talk about just very briefly through the dispute settlement body and the panel and a appellate body. Now here you need to prepare with you the dispute settlement understanding, Article 2. Now please have with you the text. Now here there's a few characteristics that you may notice with the DSB. Now mostly this is a political organ which have the right to supervise dispute settlement activities. And it has been composed by all WTO members that I have mentioned earlier. And for this body, generally it takes decision by consensus. If you read through the text, that's mean Article 2, then well, here in Article 2, please have a look at paragraph 4. As they have noticed that where the rules and procedures of this understanding provide for the DSB to take a decision, it shall do so by what kinds of rules of making decision? By consensus. Okay, and so when the DSB have to take any decision, then they're gonna apply consensus. But in the following cases, they will not apply this consensus rule, but using negative consensus. Okay, so it's a little bit complicated, but I need you to focus. The first thing, if the DSB need to take any decision, the main rules is consensus, which is a kind of traditional procedures under the WTO system. Okay, but in the 3 cases that's mentioned on the slide right now, they're gonna apply negative consensus rather than consensus. Now the reason why the WTO have to apply or to change the decision-making rules is because, as I have mentioned earlier, if they decide by consensus, the decision gonna be always facing with the risk of locking by the respondent. Now, in order for you to understand deeply into this kind of mechanism, I need you to focus on this thing. Now, the first rule is that negative consensus has only been applied in the 3 cases as I have listed on the slide. The first one in when they need to establish a panel for a dispute, okay, which has been mentioned in Article 6.1. Also, when they need to adopt the report, which has been prepared by the panel and the appellate body. What does that mean? Well, the adoption of report. This means that you know that the result of the work of the panel and the APs are only reports, and they will never be the judgment of the dispute settlement body under it has been like moving in the adoption procedures running by the dispute settlement body. And so this is this step is super important, because without these adoptions, there will be no judgment. And so the result of the dispute settlement procedures equal with 0. And so this step is super important in the system. And so they apply negative consensus. We may go very slowly through this step, and so you don't need to worry about that. The last issues that are going to be decided by negative consensus has been mentioned in Article 22, paragraph 6, which the DSB have the right to authorize of suspensions of concessions. What does it mean by suspension of concessions? That's mean when the dispute settlement procedures come to an end, and they have the judgment, but the respondent have not followed the requirement under the judgment. And so at that time, the complainant have the right to ask the DSB to give them the right to stop doing specific obligations that they need to do in reverse to the actions of the respondent. Trong cái tình huống này, nó có nghĩa là DSB có quyền được cho phép cái bên thắng kiện đấy các bạn được làm gì, được trả đũa cho cái việc mà cái bên thua kiện ấy, họ cái bên thua kiện họ không chịu tuân thủ cái phán quyết, thì DSB có quyền cho phép cái bên thắng kiện được áp dụng cái biện pháp trả đũa. Và cái thủ tục để cho phép việc áp dụng biện pháp trả đũa này sẽ áp dụng cái quy tắc là negative consensus, tức là đồng thuận nghịch hay là đồng thuận phủ quyết. Okay, so we come back now for these three issues, for these three decisions, the dispute settlement body have to apply a negative consensus in order to approve a specific decision. Now here, in order to understand what exactly negative consensus mean and how they're going to be organized, now I need you to prepare with you Article 6.1 of the dispute settlement understanding. Let me share the screen right here. Okay, I need you to spend a couple of time reading through this text, and then you may provide further explanation about that. Now, Article 6, regarding the establishments of the panels. You read through the text, and then please explain to me that how you understand about these provisions. Okay, have you finished reading? So please kindly explain to me how you understand negative consensus going to be applied. Now, the chance for this, a chance for a decision to be adopted is high or low. Or in other words, how many percent that a panel going to be established if we apply these kinds of negative consensus rule? Any volunteers?
Can you repeat the question?
Well, I have asked you all to read through Article 6, Paragraph 1, and the question is how you understand negative consensus going to be applied in this situation. Now, let me make clear right here. Right. Now, if the complaining party so requests, a panel shall be established. Now, shall be established, that means it's a must. Now, under the legal language, now shall gonna be applied in case there's a must requirement, right? Now, if the complaining party so requests, a panel shall be established. Okay, when? At the latest, at the DSP meeting following that at which the request first appeared. Okay, so right here, for the first part of the sentence, they say that if the complaining party requests for the establishment of a panel in order to solve a dispute, that means a panel shall surely be established at the next meeting of the DSP meeting, right? Well, today I submit my request for establishing a panel to dispute to solve the dispute between me and another country, and also for the next meeting of the DSP. It will automatically approve the decision, right? And so at the next meeting of the DSP, a panel shall be established. But for the second part of the sentence, right here, you see or you have noticed that they have prepared just only one case that the panel will or cannot be established, and that one case only happens when and only when the DSP decide by consensus not to establish a panel. What does it mean by the DSP decide by consensus not to establish a panel? Now you all have the idea about consensus, right? How can they run consensus? How can they apply consensus in a meeting? Anyone?
So the way they apply consensus at a meeting is when a representative or of a member at the meeting oppose. They say no to the proposal.
Okay.
So that's how they apply consensus.
And so, all right. So if a member use their veto at that meeting, that means that decision gonna be approved or not?
No. It's all right.
Okay, so at a meeting that they applied consensus. Now, normally the general director gonna ask that, shall we right now we're gonna make our decision on a specific issues, okay? And so they may raise the questions, and the members at that time, if they want to to provide their objections, and they need to raise their voice. And in such case, then the decision will not be approved. That consensus. Okay. Now we've moved to not negative consensus. Now here they say that the DSP decide by consensus not to establish a panel. So right here, the decision is not about approving something, but not approving something. Okay. So right now, the chairman gonna ask. We're gonna have to decide on the issues that we will not establish a panel for this specific case. Any objections? Okay. And so in this case, what does it mean by not to establish a panel? Now at this time, if we don't want this decision to be approved, we need what? Now take a couple of time thinking about the decision of not to establish a panel.
We need to say that we agree to establish a panel.
No, it's not. Now the decision right now is not about establishing a panel, but the decision which we gonna need the support from all the objections from the member is not to establish a panel. Understand? Now such consensus of not to establish a panel, is it easy to get that consensus? That means consensus, that means no objections, right? Okay, and the decision right now is not to establish a panel. And now you may think about the chance that it does not have any objections to this requirement, to this establish a panel. Now you may think about this closely. So when we talk about the dispute settlement body, we know that it's contained on WTO member. And now here in this decision, if we think about the willing or the requirement or the wish to have a panel to decide this case, now there's the complaining parties is always like to have that decision to be approved, right? And so he always wished to do so because this request is submitted by that member. Okay, so this is the country which always support for this decision, and so the decision of not to establish a panel always have at least one vote to be objected by the disputing party, and therefore it's always happen. You got exactly what I mean?
I have one question. So, if the complaint party is wanting the panel to be established, why they are included in the vote? Because basically, when someone proposes a suggestion, they are not entitled to vote because definitely the result of their vote will be opposed to, for example, in this situation, is to not establish the panel.
Okay, that's a nice question. But now you may and here, if you have that question in your mind, you have to come back to the system of the WTO, that they have the traditions that this organization has been a kind of member rulings organizations, and so all the decisions have to be decided by the member. Okay, that is the first rule. The second one, now if there's two people that's arguing, all right, so the one who break the rules or to do a violation of the law, and because of that violations, it leads to a kind of a lot of negative effect to another member. And now, which one is the people you may protect? The one who are violating the law, or the one who that their right has been limited? What do you think?
The party that has been violated the right.
So you need to protect the one who are violating the law?
No, the one who has been.
So that is the reason why now right here in this system, when the DSP have to decide about a thing, now the complainant have the vote as equal to the respondent. Understand? Because if you let him out of the room, then the respondent right now have the right to decide, and he's gonna be the one who never expect for a dispute settlement system, right? I better play outside. I better say no. I don't want any panel to listen about my case. I don't want for them to give any judgment about my violations. See? And so right here, the system has to choose between the two, and they need to protect the weaker. They need to protect the one who their right has been limited by another violations of another members. See? And so right here, they choose to apply negative consensus. Now I think some of you have not quite clearly about the rules, so it's better for me right here to give further explanations. Now, in the terms of GATT, normally they apply traditional favorite rules that mean consensus. And so when a dispute settlement, when the GATT committee sits there to approve for the establishment of a panel, well, normally when they sit there, always the respondent have one vote, right? And they use their veto right to stop or to block the establishment of the panel. That's the problem. Okay? And so when they move to the WTO time, they change it to negative consensus. Now, right here, the decision is that now the chairman going to raise the question. Now we may consider a decision of not establishing a panel in this case. And so in this case, normally always the complaining countries will normally unlikely to change its will or its view unless the dispute has been settled. And so normally we always have this veto coming from the complaining parties, and so we will surely have the panel to examine the case. Class, do you got the point? Now you get the point right here. Now when we now maybe we move further to Article 16.4. Now here, this is the procedures for the adoptions of the panel report. Now you may have the same, you may see right here the same wording. Within 60 days after the date of circulation of a panel report to the member, and the report shall be adopted at a DSP meeting, unless a party to the dispute formally notice to the DSP of its decision to appeal, right here, or the DSP decide by consensus not to adopt the report. Now that means right here that now there is always at least one country, one member, the complaining country, right? They expect for that report, and so they will never, they will can at any time using this veto right of the decision not to adopt the report. And so we can always make sure that this report can be adopted. And that is the reason why they say the report shall be adopted at a DSB meeting. That means it surely be adopted at the next meeting of the DSB, right? And so in this case, it's called automatically, because all the things going to be approved automatically via the dispute settlement decision making of applying negative consensus. And that is how they describe this mechanism as an automaticity mechanism, because all the things going to be approved. But all the things, that mean all the things we have mentioned earlier, which stick to the establishment of the panel, stick to the adoption of the report of the panel and the appellate body, and also the authorizations of the suspension of concessions only. Okay, so in these three cases, and only in these three cases, that they applied a negative consensus. Let me go back to the slide. Okay. Now, as I have mentioned before, these provisions it's remove the opportunities that existed under the GATT procedures for blocking the multilateral dispute settlement process, and this new consensus rules it ensure that the whole dispute settlement procedures are gonna be it's gonna move forward in the future more rapidly and automatically in compared with the GATT time. Okay, so this is a very special decision making under the system of the WTO. Right. Now here, as you can see on the board, there's 5 main stages in resolving a dispute under the WTO system. Now we may have here the consultation phase, tức là bước tham vấn, okay? And then if it's failed at this stage, then the dispute may move to the next stage, that is panel review. And it can be finished here if all the if they all happy with the result. But if the party, the disputing party, don't agree with the judge with the report of the panel, they can submit their request for AB review, and then the dispute gonna move to the next step, appellate body review. And then when they finish this step, the result is going to be the report providing or preparing by the panel or the AB, and so we need a step of adoptions by the dispute settlement body. But you all know that you have the idea that this step is automatically, and so when we have the judgment, then it's going to move to the implementation stage. Okay, and so although we have here 5 stages, but you know that it is not necessary for a specific dispute to fully going through these 5 stages, right? It can be settled at any stage, and along with these procedures, it can at any stage move to escape out of the system by choosing good offices, conciliations, and mediations. And the WTO provide or suggest this right for the disputing party to stop the dispute settlement system at any time they wish to. okay, and move on to another channel to solve their conflict. And that's mean what is it? Positive solution, which I have mentioned last time, that the WTO encouraged their members to solve the conflict by themselves, and as long as they can solve it, then the relationship between the two is okay. Now they don't they will not expect, they will not refer for the judgment from the panel or the appellate body, because that's going to be the last step, the last expectations of the system. Okay. Now here, this is that procedure in with more details in specific step. Now, when looking into this map, it has a broad map. Then you may have the idea how they're gonna organize a dispute settlement procedure. Here they also provide specific timetable for different bodies to follow under the rules. Now, as I have mentioned, although much of the procedures does resemble a country for tribunal, now the preferred solution is for the country concerns to discuss their problem and settle the dispute by themselves. And so here you see on the right side of good offices, conciliations and mediations right here. And they can choose at any time to move out to the procedures of dispute settlement of the WTO. Now, the first step, the first stage is consultations. As I have mentioned, I explained to maybe one member of this class last time that the consultation is a mandatory requirement under the system of the WTO. That's how they apply the requirement or their aims to support for positive solutions under the system. Now, at first stage, they ask that both parties have to do the consultations first. That means they have to discuss about their conflict. They have to talk about that first. And that is the mandatory step in the procedure. Now, if the conflicting country never talk about that first, then the complainant country have no right to submit its request for panel establishment. Okay. Now they have to first meet the requirement that they have to do the consultations, and then if the consultation failed, then they may right now at that point, at that step, have the right to request for the panel establishment. Okay. Now, here, when the dispute settlement body established and a kind of ad hoc panel, then that panel will conduct hearings, and the result of that procedures is they're gonna issue a non-binding report on the merits of the case, and the recommendations of a panel only become binding with the parties only after they have been adopted by the DSP. But here, you know that this adoption step can be applied negative consensus. Okay. Now, next step. If the panel has been prepared their report and the report is issued to the parties before it's going to be circulated to the member. And at this stage, if the party don't agree with the report submitted by the party, then right here at this step, they have to send the request for appellate body review at this stage. Okay, and so with this kind of request, the dispute going to be moved further to the next stage, appellate body review. Okay, and so the appellate body review is contain of 3 members at the higher level of the dispute settlement mechanism, and so the appeal is heard before a 3 judge divisions of the AB, and this AB may be provide any decision, like they may uphold, they may modify or reverse the legal findings of the panel, and the result of this step is the report of the AB. This report going to be adopted by the DSP, and it's going to be given binding force unless the DSP decide otherwise. But you know that this is a negative consensus going to be applied, and surely it's going to be automatically approved. Okay, and so this is here are main stations that
xem cái này
sufficient a dispute by going through these procedures in the system. Now we may move very briefly through the specific step or stages of this procedure. Normally I may guide through the main idea, and I will recommend you to read further to the text at home.
chiều nay không đi nè.
Okay? And so the first stage is
Em mới nhắn cho mấy nè.
consultations.
3 giờ chiều
Now you must have in front of your eyes Article 4.
3 giờ chiều nay tiêm.
You may have a look at that. Maybe skimming through the text. Then to have a very basic idea about that, and then we may discuss about it later. Article 4 on consultations.
Tiểu học Trần Quốc Tuấn.
Miss, I have a question.
Okay, please.
So it's not about the consultations, but can you please explain the difference between the panel and the AB, the panel review and the AB review?
All right. When we've moved further after this step, consultation, we will move to panel review and AB review, and then after that,
Okay, thank you.
Okay, now right here, I need you to come back to the slide and follow my instructions. Now, so when you read through Article 4 regarding to consultations in the system, you may know that who gonna have to go into this step. Now, at the dispute settlement procedures of the WTO going to be started by a request of consultations of a member of the WTO. And so under Article 4, Paragraph 3, then you may have the idea that when this has been starting, that means a dispute settlement procedures has been opened at that stage. Now, here's some point to be put in mind. Now, this consultation procedures has been confidential. That means now things gonna be prepared and do at first by the complainant parties. When they submit their request for consultations, it needs to include the violation. It needs to clarify what exactly the violation here in the case, and that complainant party also have to state or to define legal basis for its complaint. Okay, so here's the thing which have to be included in the request for consultations. And the first thing in this request has to be sent to the respondent, but it's also circulated to all WTO member, because as I have mentioned at many times that this is a member-driven organization, and so all the things have to be watched by the members of the system. Okay, and so but here we have no the WTO Secretariat have nothing to do at this stage. That means how we say that it's a kind of confidential process. Only the WTO member have the idea about the arising issue, about the conflict at this stage, and the things happening amongst the member. Maybe we just pass by the third party. We don't have much time to talk about third parties right here. Now, please follow this slide, which is presenting Article 4, Paragraph 3 about the time and cases and that they have to follow. Now, the first thing, the complainants have to submit their request for consultations. Okay, and so here we have two cases arising. The first one, if the requested member reply within 10 days, the reply is going to be, okay, we can talk about that. I also want to explain. And so if it happened like that, then both party gonna try to organize the meeting to talk about their conflict. Okay, and so if within 10 days, within 30 days since that date, if they try to consult with each other, but they fail, right? And then the complainants can right now have the right to request for the establishment of the panel. Okay. In other case, if the requested member reply within 10 days, but after that they change their mind and they don't want to talk about their conflict anymore. And so at that time, the complaining parties also have the
Ta làm bài
right to
xong
request
rồi,
for the
ta đợi mấy đường
establishment
khác nó
of the
xong.
panel. Okay, so at the first case, that means the requested member replies the request for consultations of the complainant. Things gonna be organized. But in case at first sight, after receiving the request for consultations, the requested member just ignore that request, then the complainant party strictly have the right at that time right away to request for the establishment of a panel. Okay, so here is all the step for consultations. Now, if the case gonna move to the next step, to the next stage, then a panel gonna be established automatically by applying negative consensus. And now here at in the request for establishing the panel, the complaining party have to identify specific measures which are raising the dispute. They also have to provide a brief summary of the legal basis that their claim based on. They also have to explain or to clarify or to prove that how consultation has been failed. Okay, and so with these three things listed or included in the request for establishment of the panel, then this document have to be addressed to the chairman of the WTO, and it's also sent a copy to the defendant to make clear that they're going to run through the procedures of the WTO rather than doing it by themselves. Okay, and here it is also the right of the defendant to know that their measures right now are going to be facing with a risk to be examined by an individual, an independent body of the WTO specified to this work. Now here, because Nga have just asked about a panel, and now we have chance to talk about it deeply. Now I need to read through Article 6, 7, and 8 just very shortly, so that I may provide right here further explanation regarding this step. Article 6, 7, and 8. You may not have much time, so I think it's better for you to focus on Article 8. Okay. Now here there's two main things that I wish to share. The first thing is the terms of reference of the panel, which has been mentioned at Article 7. Okay. Well, normally, what exactly the terms of reference? Tiếng Việt mình gọi là điều khoản tham chiếu các bạn. Điều khoản tham chiếu nó là cái gì? Nó là cái nói một cách nôm na là khi mà mình gửi một cái yêu cầu thành lập ban hội thẩm như mình giải thích ở trong cái slide trước, là các bạn sẽ phải liệt kê ở trong đó là người ta vi phạm cái gì, và theo đó thì mình nghĩ là cái hành vi vi phạm đấy thì nó vi phạm cái điều khoản nào của Tổ chức Thương mại Thế giới. Cái việc này rất là quan trọng. Tại sao? Tại vì nếu như mà bạn xác định không đúng, ví dụ như là họ vi phạm 10 cái vấn đề mà bạn chỉ xác định được có 5 vấn đề thôi, thì ban nội thẩm họ sẽ chỉ xét xử 5 vấn đề đó thôi. Hình dung không? Chứ ban nội thẩm sẽ không có ngồi đó và analyze the case, rồi sau đó thì họ xem giải quyết tất cả các vấn đề trong đó mà họ nghĩ là phải giải thích. No. Họ sẽ chỉ giải quyết cái gì mà bên nguyên đơn họ đưa ra thôi. Được chưa? Và tại sao đấy là lý do vì sao mà mình phải nhắc về điều khoản tham chiếu, bởi vì điều khoản tham chiếu này nó sẽ hạn chế và nó cũng sẽ cung cấp khả năng cho một bên trong cái việc tranh chấp được giải quyết. Nếu bây giờ trình độ của mình kém quá, mình xác định không có đầy đủ các cái vi phạm của phía bên kia, thì khi mình đưa nó vào điều khoản tham chiếu này, nó sẽ tự hạn chế quyền của bạn luôn. Được không? Okay, we come back to the terms of reference, and that is the reason why it's important, and it is very super vital in a case, and so it needs to be closely and well prepared before the case, and also the terms of reference has to be notified to the panel and also the respondent, because the respondent have the right to know what exactly the thing they are complaining and to prepare about such kind of argument, and so it is vital for us to talk about Article 7, and we may also have chance to experience this by analyzing one case requested for presentation in the next coming weeks, I hope. And you may have a clear idea about how important these articles. All right, now we talked about the panel. And when you read through the text, who want to sit in a panel body? Well, normally they are well qualified government and even non-governmental individuals. So these people may be professors or like sometimes a minister of a WTO member country. They will not work for the WTO, but the Secretariat have prepared a list of these people, and because the WTO don't want to build such a body of panel groups, and so they just prepare a kind of a list of people who have meet the requirement to act as a panel members. And in such case, in a specific rising case, the DSP may approve groups of panel members that has been suggested by the Secretariat of the WTO, and in such case, that ad hoc panel going to be present and work and run their work. We might spend more time to read through the text of Article 8 in order to have a better idea of who's going to sit in that body. and how they're gonna decide or appoint a panel members in a specific case. Well, normally they have a specific requirement. Let's say in paragraph 1 and 2 of Article 8. Now you need to spend time to read Article 8, paragraph 10. That's relating to the case that involve with a kind of developing country, developing member of the WTO. It's also a special paragraph to disputing party that is this developing country in the system, and I think that's all. So for Article 8, paragraph 1, 2, 5, 9, and 10. These are specific paragraphs that you need to spend more time reading at home. If you need further questions, then you may also raise right here, right now, in the class. Monocle complaint. I don't think that we have time to talk about this. For the panel procedures, they have prepared the working procedures in Appendix 3, but it's just it's all about procedures, and so it's okay right here for us to know that it has been mentioned at that document, and that's enough. Now here, as Nga have just asked that what exactly the panel gonna do, and what is the difference between the panel and the appellate body. Now, here's the thing you need to have in your mind. Now, when we talk about the functions of the panel, please stick on Article 11. Now, normally the panel gonna do the hardest work in this procedure, right? They have to assess objective assess on facts of the case. They have to analyze on the fact and the document has been submitted, analyze the conformity of the measures with their provisions, and the final part is going to be they have to draft the report with the rulings. Normally drafting panel report for me is the most important stage of the panel work. Well, the dilemma is that the panel is not supposed to make or to set new rules under the system, and also so that means they have to stick with the law of the WTO, and all the things arising in the real life. That means that the conflict or the violation, specific violation of a member, have to be analyzed and to evaluate how it's conformed with the requirements of the WTO. And so also at the same time, it is also the job of the panel to assist the dispute settlement body in finding a positive solution. And well, this is hard work, implying difficult choices, even when there is no overt negotiation happening. Now, well, normal report of the panel have to set out these things: the findings of facts, and the applicability of the relevant provisions, and how in this case these actions as specific actions has been considered as a violation or not, and also the basic rationale behind its finding. And so here, the panel report gonna move and have to circulate it to the disputing parties. And it has to be put into the agenda of approving by the DSP. Now, that is the panel procedures.
Teacher,
Yeah?
what happens if the country does not comply with the DBS report?
Oh, all right. Now, the DSB does not provide a report. The report has been prepared by the panel and the appellate body. That's the first point, okay? And until this report has been adopted by the DSB, then it's become the judgment. Okay, so at this step, we are staying at panel procedures, and if the panel report has been adopted, then it's become the judgment. And for the next stage, then we may talk about the implementations. Okay, so right here, we are just here, and we talk about this step first. We're gonna move step by step so that you have a very clear pictures about how the procedure is going to be organized. Okay? Hopefully we finish this today. All right, so here we have the adoption of the panel report. You have the idea about Article 16, so you know that is automatically, huh? Okay, it's going to be, but the panel reports will not be considered for adoption until 20 days after it has been sent to the involving parties, because these parties need to have this 20 days to consider and to decide whether to request for AB review or whether to accept for that report. Okay, if there's no objections, then totally the panel report going to be adopted within 60 days of circulations. Okay, that is just the main rules. In case there's a case of request for appellate review, then this step should not take more than 60 days. And well, normally at most they should take about 90 days. Now the work of the appellate body is a little bit different with the panel review. Now here there's a few things you need to have in mind. Now, this is a kind of innovations of the WTO, which we cannot find this stage in the terms of GATT. For the rules applicable to appellate review, it's going to be mentioned in Article 16, 17, 1, 3, 18, and 19. You can have a look at that with this guiding later when we finish this class. Okay, that's not too much important for me to talking about that right here. But here are the things you have to have about appellate body member. When we talk about appellate body member, please have a look at Article 17. 17. Right here. Okay. Now, when we talk about the appellate body review, then this Article 7 provide all the provision relating to standing appellate body. Now here, as I have mentioned that the standing appellate body nghĩa là thường trực các bạn, một cơ quan phúc thẩm thường trực. Nào nó khác với lại panel, với lại ban luận thẩm ở chỗ là cái ban luận thẩm thì nó chỉ là ban luận thẩm ad hoc thôi, nó sẽ được thành lập theo mỗi case và nó sẽ tự giải tán sau cái case đó. Thế nhưng mà đến cái cấp phúc thẩm thì nó có một cơ quan thường trực luôn. Thường trực nghĩa là sao? Cái kết tiêu trả lương cho những người này á, được chưa? Để ở đây và làm việc full time với tư cách là thành viên của cơ quan phúc thẩm. Okay? And so a standing appellate body shall be established by the DSP. And this is the how can I say? The Achilles heel that has been used by the US, because you have know the idea that the US right now is blocking the appointment of the ABE members, and therefore this body cannot be effectively run since 2018. Okay, and so here they say that a standing appellate body will be established by the dispute settlement body, and the person serving on this body shall serve in rotations, and well, normally they have it has been composed of 7 members, and they're gonna work in rotation. Now for each case, only about three person gonna sit in a case, and they have 4-year terms, and they may be reappointed once. And for the requirement, you may read further in the text in order to know about the requirement for people who sitting or serving in this body. But there's a few things I need to share. Here, Article 17 also mentions that only parties to the dispute, but not third parties, may appeal a panel report. That is very important for a case, because this might be a lot of third parties joining into a dispute settlement mechanism or for a specific case, but they will not have the right for the appeal. Only the complainant and the respondent have that right. Okay, and for the work of the appellate body, they will not review the whole case, but only focus on the issues of law covered in the panel report and legal interpretations developed by the panel. Now here is the thing you have to have a look at. Now when we talk about Article 17, paragraph 6, what does it mean by issues of law? That means all the things focus on the law of the WTO, and the interpretation of the panel. Is anything wrong with that explanation? Anything needs to be fixed? Okay, so here the WTO prepared this system, this second stage of re-examining the dispute, only to fix the error that's made by its system, but not to fix the error made by the member. What exactly does that mean? Now, for example, in the stage of panel review, now I myself as a complainant or as a respondent, I have I cannot prepare that document. I cannot find out that kind of reasoning, etc. And so I have not include that kind of fact in all the documents submitted to the panel. But later, when I find out more evidences, find out more for example, more facts that support to my case, and then I wish to submit these kinds of documents to the appellate body. In such cases, the appellate body will not consider, will not examine those new facts that adopted by the disputing party. Okay, now their work is focusing on fixing any error made by the panel only. Is there the lower body giving insufficient explanations, interpretations of the WTO rules? So this is the second chance provided for the members to reconsider the examination of the WTO on the WTO law only. Okay, and so this is the thing you need to keep in mind. And maybe we come back to the slide. Now, right here, the appellate body will not work or stick with any government because they work for the WTO full time. Okay, so these are the things. Now, I need to right here. May I introduce to you? This is a kind of the appellate body member with added in 2016, because after this year in 2017 the US used their veto right, and since that time the appellate body have not their full member, and it is the sad story that since 2011, the appellate body of the WTO have only 3 members rather than 7, and all the work has been solved by these 3 appellate body members. And here, right now, in 2021, there are currently no member of the appellate body under the WTO system, because the terms of the last sitting appellate body member has expired on November 2020, and so right now there's no appellate body at the WTO. Now here, why the US have to do so? Well, normally you all heard about the trade war rising between the US and China. And also at that time, then the US attacked to the system of the WTO. And here, because the US is the one who draft the law for the whole world, that means all the document, the agreement under the WTO system has, firstly, has been drafted by the America. And so they know the Achilles heel, and they know where exactly the weak point, the dead point of the organization. And so when it acts, the system found that. And well, normally the architecture is the one who knows pretty well how to destroy the building, how to destroy his constructions. And so here, you know why when the US, when the America act, the system cannot be worked well. When you enter when you check out the WTO website, and you know that right now the system has worked only at the panel level. Okay. So that's all the things for the appellate review. Now I jump into the implementations. As I need to finish this work today, and so we can move to the second seminar by Thursday. So I need you to stay here with me maybe for further 10 minutes to talk through these issues. Now for the implementations, Well, you all know that the result of the work of the panel or the appellate body is a report, right? And this report needs to be approved by the dispute settlement body by applying negative consensus, right? And normally in these report, when it has been adopted by the DSP, it's going to become the judgment, and at that time both parties need to implement or need to follow all the requirements suggested in this judgment. And normally if the panel or the AB found violations, it's gonna recommend that the violating member have to bring the measures into conformity. That means they have to stop the violations. Okay. Well, normally within 30 days of the adoption of the report, the member have to show their intentions about the implementing this judgment under Article 21 of the Dispute Settlement Understanding. For this implementation step, here it is better for you to follow this structure. Now, relating to the implementation step, you need to follow Article 21 and 22 of the Dispute Settlement Understanding. Well, normally, when there's a case of judgment and as for the implementation, well, normally the main rules. Let me show you the law. It's better to follow. Right here. Okay, now right here the main rules is that a prompt compliance with recommendations or ruling of the WTO is essential. That means they prefer for the implementations of the recommendations immediately. Okay, but normally changing a law or a policy is not, it takes time. Sometimes it takes 6 months or years to change the law. And so normally, as you can see here in paragraph 3, at a DSB meeting held within 30 days after the day of adoption of the report, the member concerned shall inform the DSB of its intentions. That I want to follow the rules, but I need much more time to doing so. And so in such case, they're gonna have suggest for a reasonable period of time to do. Okay. Now, if after this reasonable period of time, but the concerned member have not followed the requirement of the report, then we might move to the next step, that the complainant or the winner of the case may ask for compensations and or the suspension of concession. That is the questions raised by V before. Now, if after the reasonable period of time there's no compliance with the rules, then they may have the right, the complainant may have the right to ask for compensations or suspension of concession. Now, compensations has not popular in the system of the WTO because of some technical problem, but I don't think that we have time to discuss about that. And so we just pass by compensations and move on to the suspension of the obligation under the system. Now here we need you to focus on paragraph 3 of Article 22.
Dạ. Dạ.
Now the rules applying on suspension of concessions, tức là tạm hoãn thi hành các cái nghĩa vụ. Tóm lại là trong cái hệ thống này, cái bước cuối cùng mà một cái biện pháp phải đáp ứng đấy là họ phải tuân thủ cái phán quyết. Thế nhưng mà phán quyết thì thường nhiều khi mấy cái nước mạnh họ cũng chả thèm quan tâm đến phán quyết luôn thì sao? Thì cái hệ thống này họ nói rằng là tôi sẽ đảm bảo việc giám sát việc thực thi phán quyết. Bạn sẽ hình dung là với mỗi cái kỳ họp của cơ quan giải quyết tranh chấp ấy, thì cái nước mà phải thực thi phán quyết họ sẽ phải đi lên để trình bày là tôi đã thực thi phán quyết chưa. Cho nên đấy, cái sự watching, cái việc mà các cái quốc gia trong tổ chức thương mại thế giới họ watching cái việc này ấy, họ giám sát việc này, nó cũng là một cái áp lực đối với cái nước mà phải thực thi phán quyết. Và thường là với mỗi cái lần báo cáo như vậy ấy, thì đây là một cái áp lực mà tổ chức thương mại thế giới đặt ra cho các cái thành viên của mình. Và đấy là lý do vì sao mà các cái kỳ họp của DSP, các cái kỳ họp của cơ quan giải quyết tranh chấp, nó là cái lúc mà người ta kiểm tra cái tiến độ thực thi phán quyết của tổ chức này đã được thực hiện chưa, được chưa. Mà thế nếu như mà phán quyết không được thực thi thì làm sao? Hồi nãy có bạn hỏi. Thì cái nguyên tắc chung ở trong cái hệ thống này là cái nước mà thắng kiện đó họ sẽ có thể trả đũa, được chưa. Là cái nguyên tắc của việc trả đũa là đầu tiên là phải trả đũa trong cùng cái lĩnh vực mà vi phạm trong lĩnh vực nào thì trả đũa trong lĩnh vực đó, được chưa. Nếu vi phạm xảy ra trong lĩnh vực thương mại hàng hóa, ví dụ như là anh tăng thuế nhập khẩu của tôi quá cao đi chẳng hạn, đúng không, thì ví dụ như anh tăng thuế nhập khẩu đối với sản phẩm là gạo của mình đi, được chưa. Và về nguyên tắc theo đúng luật của WTO là anh không được phép tăng thuế nhập khẩu bừa bãi, trái với cái cam kết ban đầu của anh, thì tôi sẽ có thể tăng thuế nhập khẩu đối với sản phẩm nhập khẩu của anh và nước của tôi, được chưa. Thì đó gọi là tăng thuế, đó là trả đũa trong cùng cái lĩnh vực vi phạm. Nhưng mà bạn sẽ hỏi tôi là bây giờ em nhập khẩu gạo vào nước của anh nhưng mà anh đâu nhập khẩu gạo vào nước của em, đúng không. Thì em trả đũa với anh đâu có ý nghĩa gì. Em có tăng thuế đối với sản phẩm của anh thì cũng vậy thôi. Thì ở trong cái điều 22 này họ nói là riêng về cái câu chuyện lĩnh vực đó, thì đây này, bạn thấy dưới điểm F mà tôi present ở trên màn hình này, thì ở trong cái hàng hóa, trong cái lĩnh vực hàng hóa không có phân chia từng lĩnh vực, được không. Như vậy có nghĩa là tôi có thể trả đũa lên bất cứ hàng hóa nào của anh mà tôi nhập khẩu vào, miễn là nó có cùng cái tỷ trọng tương xứng nhập khẩu với cái hàng hóa mà tôi bị anh vi phạm, được chưa. Rồi sang đến dịch vụ thì mới chia thành các lĩnh vực khác nhau, là từng cái ngành lĩnh vực cụ thể thì sẽ là các cái lĩnh vực khác nhau đó. Và trong cái hiệp định TRIPS thì họ cũng chia thành lĩnh vực. Thế còn ở trong thương mại hàng hóa thì họ không có chia lĩnh vực, được chưa. Nào bây giờ thì mình sẽ có lại tiếp tục một cái câu hỏi nữa là nếu mà em trả đũa trong cùng lĩnh vực nó cũng không có xin nhê gì đối với cái nước kia thì sao. Thì khi đó WTO suggest là em sẽ có thể trả đũa khác lĩnh vực trong cùng một hiệp định. Ví dụ như là họ vi phạm với em trong lĩnh vực ngân hàng chẳng hạn, thì bây giờ em có thể trả đũa trong một lĩnh vực không cần lĩnh vực ngân hàng, mà em trả đũa trong lĩnh vực dịch vụ y tế chẳng hạn, là cái lĩnh vực mà phía đối phương họ rất là mạnh, được chưa. Thì đó là trả đũa khác lĩnh vực hay là chéo lĩnh vực nhưng vẫn trong cùng hiệp định về dịch vụ. Theo kịp không? Đó. Rồi nếu như mà biện pháp trả đũa này cũng không có xin nhê gì luôn, thì bây giờ họ cho em được trả đũa chéo hiệp định luôn. Nghĩa là vi phạm trong lĩnh vực hàng hóa thì em có thể trả đũa trong vi phạm trong hiệp định về hàng hóa em có thể trả đũa trong hiệp định về dịch vụ, được không. Thì đó gọi là trả đũa chéo hiệp định luôn. Tại sao? Tại vì bạn hình dung là ví dụ như các nước nghèo như mình đi, mình ít khi phát triển service lắm, mà mình tập trung vào xuất khẩu hàng hóa nhiều hơn. Đôi khi mình mang hàng hóa sang các nước khác mình bán, mình bị họ chèn ép chẳng hạn, mình bị họ ví dụ như áp thuế chống bán phá giá quá là phi lý đi, phải chưa. Mà mình áp dụng lại một biện pháp trả đũa trong một lĩnh vực hàng hóa khác thì nó không có ép phê gì cả. Tại vì ví dụ như trong trường hợp cụ thể Hoa Kỳ mang hàng hóa nhập khẩu sang một cái thị trường bé tẹo như mình thì nó đâu có ý nghĩa gì mấy, phải chưa. Và hàng hóa thì cũng không phải là cái lĩnh vực mà Hoa Kỳ thật sự xem trọng nữa, mà sở hữu trí tuệ và service thì mới là các cái ngành mà mang lại nhiều mang lại nhiều tiền và lợi nhuận cho họ. Và khi đó thì nó sẽ có ý nghĩa rất là lớn cho các nước đang phát triển, các nước nghèo, khi mà họ trả đũa lại, được chưa? Nào, như vậy là đến đây thì mình kết thúc cái bài cái phần liên quan đến đến cái cơ chế giải quyết tranh chấp của WTO. Không biết là các bạn có cần mình phải nói lại tiếng Việt một vài phần nào trong cái nội dung này không? Hay là bạn có thắc mắc gì không thì bạn hỏi luôn. Thì bữa sau là mình sẽ chuyển sang bài mới rồi. Các bạn có muốn hỏi chỗ nào trong đây không?
Cô ơi, cái phần thành viên của ban hội thẩm với lại ban phúc thẩm thì có phải là ban phúc thẩm là họ sẽ được chỉ định và họ bắt buộc phải tham gia vào ban phúc thẩm, còn ban hội thẩm thì không, đúng không?
Bắt buộc chỉ định là sao em?
Là appointment by DSB á cô. Còn ở trong the panel review thì chỉ cần proposal của secretariat, còn nếu như mà không có đủ proposal thì sẽ bị sẽ nominated by the DG á cô.
Nó như thế này. Nào, bây giờ cái danh sách của cơ quan phúc thẩm thì như mình nói nãy mình vừa mới nói là nó là một cái cơ quan thường trực, đúng không? Cho nên nó có sẵn thành viên ở đó rồi và họ sẽ làm việc xoay tua, đúng không ạ? Có 7 người nhưng mà 3 người làm trong một case này, rồi đến case khác thì người ta sẽ là 3 cái người khác xoay tua, thì xoay tua này sẽ theo cái thủ tục làm việc thôi, nó rất là hành chính, được không? Thế nhưng mà nếu mà mình nói về ban hội thẩm thì mình nói là không có ban hội thẩm thường trực nào hết, mà các cái cá nhân ví dụ như là nó có thể là các cái giáo sư dạy về luật thương mại quốc tế này, đôi khi như mình nói là có thể là các cái người đứng đầu của các cái bộ trưởng của bộ thương mại của mỗi nước, nếu mà họ hiểu biết về luật WTO và hiểu biết rõ ràng về cái hệ thống đó thì họ cũng sẽ có thể được đưa vào cái danh sách chuẩn bị của ban thư ký. Nào, với mỗi case thì như các bạn đọc ở trong cái điều 11 về việc thành lập ban hội thẩm thì bạn và về cái điều 8 về thành phần của ban hội thẩm thì bạn sẽ thấy là ban thư ký họ sẽ lấy ở trong cái danh sách mà họ chuẩn bị, được chưa? Họ sẽ lấy ra một cái danh sách và họ sẽ suggest với các bên tranh chấp, và nếu mà không các bên tranh chấp không có phản đối về thành phần này thì cái thành phần này nó sẽ được approve tại cái cuộc họp của DSB luôn, chứ không phải là một sự chỉ định theo kiểu như vậy, em nghĩ như vậy. Thì nếu mà em hiểu đó là một sự chỉ định, nhưng mà nó sẽ vẫn có bước thành lập cái ban hội thẩm này với sự đề xuất thành phần của ban thư ký trước, em kịp không? Ban thư ký họ sẽ lấy ra trong cái danh sách đó những người phù hợp và họ sẽ phải báo với các bên tranh chấp là có phản đối không, tại vì các cái ở trong này nếu mà các em theo dõi cái điều 8 mà khoản 10 á, họ nói rằng là khi mà một tranh chấp xảy ra giữa một thành viên phát triển và thành viên đang phát triển thì nếu như có yêu cầu của thành viên đang phát triển thì thì cái ban hội thẩm này phải có ít nhất một hội thẩm là đến từ một nước thành viên đang phát triển đó. Tóm lại là họ có quyền phản đối hoặc là có quyền yêu cầu cụ thể về cái thành phần này, và sau đó thì ban thư ký sẽ có thể làm việc tất nhiên là về mặt hành chính rồi, sau đó thì cung cấp cái danh sách này lên và vào cái cuộc họp của DSB khi mà họ quyết định cái việc là có thành lập ban hội thẩm không á, được không? Thì họ sẽ quyết định luôn các thành viên này, ban thư ký chuẩn bị sẵn rồi, được chưa? Nếu họ quyết định thành lập ban hội thẩm thì họ sẽ thành lập luôn cái ban hội thẩm với cái danh sách mà ban thư ký đề xuất đó. Để nó sẽ vẫn có cái bước đó, trừ khi mà nó sẽ có nó sẽ có cái yêu cầu cụ thể thì cái chủ như nào nhỉ, nó sẽ có cái sự chỉ định, nhưng mà cái sự chỉ định này thực ra bạn phải hiểu là trên cơ sở cái yêu cầu của các cái bên tranh chấp, chứ không có phải là tự nhiên mà chỉ định, đúng không?
Dạ, ý là nếu như mà đối với lại AB review thì những cái thành viên trong đó thì sẽ bắt buộc giống như là làm việc thay ca thì phải bắt buộc nhận cái case đó cô. Còn nếu như mà những thành viên ở trong the panel bởi vì là được propose với lại được dựa trên cơ sở là những cái member của cái vụ đó đồng ý thì họ có quyền từ chối không tham gia the panel.
Tất nhiên là họ có ở cái bước thực ra là cả hai bước em ạ. Ok, cả bước applet thôi đi cũng vậy luôn. Nếu như mà các cái cái thành viên của cơ quan em thì đừng có nghĩ là nó giống như kiểu là tôi làm công ăn lương, cho nên là tôi sẽ phải tuân theo chỉ định của tổ chức. Thực ra thì nó cũng không có đến nỗi cứng nhắc như vậy, mà thường thì các cái kể cả body họ cũng có quyền từ chối luôn nếu mà họ cảm thấy là cái lợi ích của họ có thể conflict trong cái vụ tranh chấp đó. Ví dụ cái tranh chấp đó liên quan đến đến cái quốc gia mà họ mang quốc tịch chẳng hạn, thì mặc dù là trong luật Appellate Body thì họ không có đặt ra cái luật đó, nó có cái yêu cầu đó ở tại thành phần của ban nội thẩm đó. Thì em đọc thêm ở trong cái điều 8 khoản 3 đó, họ nói là công dân của nước thành viên, các bên tranh chấp hoặc là bên thứ ba thì sẽ không được tham gia vào ban nội thẩm để đảm bảo cái tính khách quan của giải quyết tranh chấp. Thế nhưng mà cái yêu cầu này thì nó lại không đặt ra cho cơ quan phúc thẩm đâu. Đó. Thế nhưng mà dù như vậy nữa thì trên thực tế nếu như mà các cái thành viên của cơ quan này họ cảm thấy là nó có cái lợi ích mà họ sẽ không đảm bảo cái tính chất khách quan ở đây thì họ sẽ có thể từ chối và nhờ một thành viên khác trong Appellate Body họ ngồi. Cái việc này nó cũng rất là flexible, chứ không nên hiểu nó là một cái strictly rules là tôi chỉ định anh ở đâu thì anh phải làm đó. Nhưng mà cái general rules thì là nó là họ sẽ làm việc theo xoay tua, xoay vòng kiểu như vậy để chia sẻ công việc với nhau. Nó là theo nghĩa như vậy.
Em hiểu. Cảm ơn cô.
Có câu hỏi gì thêm không các bạn? Học cái bài về thủ tục nó rất là mệt đầu, bởi vì nó toàn là cái yêu cầu về thủ tục không, ngày tháng rồi chức năng này kia, nhưng mà nó cũng chỉ là một cái bộ phận của cái tổ chức thôi, nên là bạn cũng không cần phải quá căng thẳng. Và cái phần nào mà mình thấy lướt được là mình đã lướt rồi, còn cái nào mà trên lớp mà mình hướng dẫn bạn kỹ thì nghĩa là những cái chỗ đó là mình nói bạn phải về đọc thêm á, là bạn phải về đọc thêm. Ví dụ như là các cái yêu cầu về consultation, việc tham vấn này, nó là một cái thủ tục bắt buộc như thế nào trong hệ thống này, nó trình bày ra làm sao, và vì họ khuyến khích giải pháp tích cực cho nên họ đặt ra các cái yêu cầu đó. Giải pháp tích cực nó sẽ liên quan đến cái gì? Tham vấn. Thì họ bắt tham vấn là một bước buộc. Nếu anh không tham vấn trước thì tôi sẽ không xử đâu, được không? Đấy là cách để họ hiện thực hóa cái yêu cầu về thủ tục gọi là giải pháp tích cực. Nữa, giải pháp tích cực nữa nó cũng sẽ có thể thể hiện ở đâu? Là bất kỳ cái bước nào trong cái quá trình giải quyết tranh chấp này cũng đều có thể bị dừng lại và chuyển sang cái giai đoạn trung gian hòa giải nếu mà các bên muốn. Vì sao lúc nào mà tôi giải quyết bằng trung gian hòa giải thì nó cũng nhẹ nhàng hơn là đi xét xử trong một cái để đưa ra một cái hội đồng hết, có đúng không? Cho nên nếu như mà anh có thể tự chuyển nó sang thủ tục trung gian hòa giải, hoặc là ngay cả cái consultation anh tự ngồi với nhau nói chuyện với nhau mà anh giải quyết được, thì nó cũng là cái cách mà tôi sẽ ưu tiên, tôi sẽ prefer nó, tôi sẽ promote cái hình thức đó ha. Thì đấy là cái mà tổ chức thương mại này ưu tiên nếu mà mình nói đến cái giải pháp tích cực thì các bạn cũng lưu ý. Ngoài ra về ban nội thẩm thì thành phần chức năng của cái cơ quan này như thế nào, cơ quan phúc thẩm cũng vậy. Thì đấy là những cái mà mình đã cố gắng để lưu ý với các bạn ở trên lớp. Cuối hôm sau thì mình sẽ chuyển sang học về cái basic của cái hệ thống này. Cái slide thì mình đã đưa lên trên e-learning rồi, thì bạn lấy cái slide đó về bạn xem trước ha. Rồi bữa sau thì mình sẽ làm việc, bữa sau là mình sẽ chỉ tập trung vào hiệp định GATT thôi đó. Và bạn thấy là nó cũng khá là nặng nên bạn chịu khó đọc trước, xem trước cái slide để khi mà mình nói tới thì bạn follow được dễ hơn. Và cái điểm tập trung ở trong cái bài tiếp theo là hiệp định GATT điều 1, điều 2, điều 3 là những cái điểm chính 1, 2, 3, 10, 24. Nó là những cái điểm chính thì ở trong các cái slide mình đều có nốt rồi. Thì bạn chịu khó bạn đọc bài trước ở nhà để cho lên lớp bạn dễ theo dõi. Ok lớp ha, có gì cần hỏi nữa không các bạn? Nếu không thì mình có thể dừng ở đây.
Chào cô ạ.
Ok, goodbye.